Magandang araw sa lahat. The other day, we discussed the issue on whether a court in a criminal action dismiss the case even without a motion filed by the accused. And we said yes, like for instance, the court has no jurisdiction over the offense. Or when the court finds no probable cause for the issuance of a warrant of arrest. So I received a message on this. Well, he cited numerous Supreme Court ruling, but I did not read it anymore because it will take so much of my time reading those Supreme Court rulings. And he was just saying that there is a hard time for him, or a difficulty in understanding the issue. So I suppose the issue is about what? Probable cause, right? Now, there are two probable cause. The first one is the executive determination of probable cause, and the second one, judicial determination. When we say executive determination of probable cause, this is determined by the prosecutor in a preliminary investigation, while judicial determination of probable cause is determined by the court whether or not the court will issue a warrant of arrest for the accused. Okay, but this is the present rule. Well, under the new rule of under the new rules of preliminary investigation, okay, passed upon or promulgated by the Department of Justice for the National Prosecution Service, not probable cause anymore. So when a complaint is filed before the prosecutor, it could be the provincial prosecutor or the city prosecutor. If the complaint is a criminal case where the imposable penalty is at least 6 years and 1 day imprisonment, the prosecutor will conduct a preliminary investigation. Okay. Like for instance, the case for homicide or murder or rape. Now, if the office of the prosecutors finds the evidence for the complainant strong, meaning there is prima facie evidence of guilt of the accused, and there is certainty of conviction in court, then the prosecutor now will file an information or will file a criminal case in court. Well, this is the new role, and this is classified as what? An executive function, lodged with the prosecutors of the National Prosecution Service of the Department of Justice. Okay, now, if an information or a criminal case is filed in court, the court now, as we mentioned earlier, will determine whether there is probable cause for the issuance of a warrant of arrest against the accused. This is the so-called judicial determination of probable cause. So if there is probable cause for the issuance of a warrant of arrest, the court will issue a warrant of arrest. Mga kababayan, siguro nalilito daw siya. Well, para hindi malito kayong mga nag-aaral ng Juris Doctor or naghahanda para sa bar examination, balik sa basic. Doon kayo sa basic. Pag hindi nyo kasi alam yung basic, talagang malilito. So ano yon? Yung una, yung determination by the prosecutor if there is prima facie evidence against the respondent and there is certainty of conviction. Ang tawag dito ay executive determination of whether there is prima facie evidence. Dati, probable cause. Ngayon, hindi na. Prima facie evidence. Now, pag na-file na, naisampa na ang information or ang criminal case sa hukuman, aba, papasok na si judge. Pag-aaralan na niya, ito yung tinatawag na judicial determination of probable cause. So, if the court finds probable cause to detain, to arrest the accused, and to proceed with the trial, then the court will now issue a warrant for his arrest. Sana naliwanagan, lalo na yung nagtanong. Pero baka iba pa talaga yung issue niya siyempre, ginagalang ko naman. Talagang masalimuot talaga. Hindi naman ganun kadali intindihin. Pero we have to go to the basic rule. Okay, yun yung rule ng probable cause. Right? So, maraming salamat at sana nakatulong na naman itong aming tanggapan at magandang araw sa lahat.